Hi, my name is Kim Cullen, and I'm a personal injury attorney in Winter Park, Florida. We talk to people practically every day who have been involved in accidents, from car accidents to motorcycle accidents to slip and falls and practically any other kind of accident you can think about. Many of our clients get concerned when our initial conversation eventually rolls around to talking about their prior medical history or pre-existing conditions. Many people are worried that because they've suffered with some sort of pre-existing medical condition to a particular part of their body, that they won't be able to make an injury claim if that same part of their body becomes injured in an accident. They really don't need to be concerned, because Florida law is actually pretty helpful to plaintiffs when it comes to compensation for injuries that overlap pre-existing conditions. People who have pre-existing conditions can definitely make successful personal injury claims as long as they keep a couple of things in mind. The first thing they need to keep in mind is that they need to be open and honest about the pre-existing condition, particularly when they're dealing with their doctors, and also when they're dealing with lawyers or claims people or anyone else involved with the personal injury claim. So all they need to do is just come clean. Essentially say, yes, this part of my body was injured before. They need to describe what kind of problems they were having with it. If it was injured before and then they haven't had problems in a long time, they should say that. If they were injured before, they were getting along pretty well, they get involved in this accident and it's gotten a lot worse, they need to tell their doctors and the claims people that. But the worst thing that can happen, and one of the worst things that can happen in a personal injury case, is for someone to deny a pre-existing condition or to say that it wasn't bothering them at all. And then invariably the other side will do some digging around and find a medical record that shows that there's a pre-existing condition. Then all of a sudden, credibility becomes a big issue in the case. And secondly, the people need to be aware that when a case involving a pre-existing condition goes before a jury or some other fact finder, that jury or the fact finder is instructed that the jury has to do their best to apportion the injury from this accident to the pre-existing condition. So they have to be able to say, well, it's 50% pre-existing, 50% new, or something like that. That's incredibly difficult for a jury to do because it's incredibly difficult for doctors to do. In fact, it's very difficult for a doctor to justify any kind of opinion when it comes to apportionment, because then you run into the argument of, well, is it 51% or is it 49%? How do you know it's 50%? Those kinds of things. And doctors just tend to not want to get involved with those sorts of arguments. So if a doctor can't apportion injuries, then it's very unlikely that a jury will be able to apportion injuries. And the law in Florida is if a jury cannot apportion injuries, then the jury has to award the plaintiff 100% of their damages, or basically treat the injury like a brand new full injury. So pre-existing conditions are something that can potentially cause problems in a Florida personal injury case, but they're not problems that we can't solve. And in fact, we've recovered hundreds and hundreds and hundreds of thousands of dollars for clients who've had injuries on top of pre-existing conditions. So if you have any questions about how a pre-existing condition might affect a Florida personal injury case, please reach out to us. We love to answer questions. You can reach us by phone by calling 407-254-4901. You can text us to 407-644-4444, or you can even reach us through the Facebook Messenger.